etc., those offences. And most importantly, section 113, that is the terrorist act. Now, till this date or till the new act comes in force, all these acts were separate and were dealt with separately under the provisions of that act with sufficient safeguards. Like, for example, if it was organized crime, the sanction, the prosecution being lodged, all these were there just to see that the act is safeguarded. But by introducing these sections in the penal code, the police are given a tool to invoke even these sections, and it is said that if the police want to invoke this section, the DSP would decide whether to go under the MCOCA or Unlawful Activities Act or under the Penal Code. Now see the scenario after 1st of July, that these sections would be invoked rampantly and to meet whatever the desires are, with the result there would be a chaotic situation, and it would be for people like Mr. Firdaus Mirza, who essentially practices on constitution. He will have to upgrade himself with the criminal law, and all these sections would be tested on the lines of section 19, article 19 and article 21. And at the same time, those who are practicing on criminal side will also have to look into these sections from that angle. Now, you also can imagine the investigation under these sections, how those would be done and what would be the fate. Now, another section which Lord startlingly appeals to me or alarms me, they have removed section 377 IPC. Now, we know the cases, and as His Lordship has also dealt with the torture in the jails and the transgender men who are subjected to unnatural sex. Consider, when 377 is removed, what would be the effect? And if such a scenario is there, I am afraid that the legislation would be falling short to protect these persons. Now, coming to the Criminal Procedure Code, which is now replaced. Initially, you all know section 154 was the section which was introduced, which was there, and which was interpreted by the Constitution Bench of the Supreme Court in Lalita Kumari, saying that whenever there is a cognizable offence, you have to register it, with few exceptions in the last paragraph of the judgment, wherein their lordship say that if it is matrimonial dispute, commercial dispute, then a preliminary inquiry is required. Now, this is replaced by section 173, and section 173 subsection 3, I will not read it for because I know the time constraints. It gives a tool to the police machinery to make a preliminary inquiry in respect of those offences classified under that section. Now, what has happened? The Lalita Kumari's effect is wiped out by this section 173, and it doesn't only stop there. If we have the comparative study of section 167 of the old code, which is now replaced by 187, the results are devastating. You remember, under 167(2), the police are given a power to investigate. The custody can be extended up to 15 days. Now, those judgments of Anupam Kulkarni, Aslam Babalal Desai, which interpreted these provisions as to how these 15 days are to be calculated, and default bail, how it is to be obtained on completion of 60 or 90 days, as the case may be. Now, what they have done, they have replaced this under 187(2) by saying that these 15 days you can get any time. up to 40 or 60 days. Now, if a person, if he is in magisterial custody, the police can say, sir, we want to have our 2 days of police custody now. Now, imagine the case in this scenario. Till the filing of charge sheet, the police would come up with this say that our police custody is yet not completed, the duration. With the result, till charge sheet is filed, forget about the bail. Now, if this is the scenario which is being introduced, then all these provisions will have to be considered by the courts, the high courts, and again, we all know there would be difference in the judgments in respect of 187.2 as to how these 15 days to be calculated, and then ultimately we will have to look forward to the decision of the Supreme Court to label or to decide this issue once for all. Secondly, 436, which was the section which was in the old code, which says that if you have undergone a sentence of half of the period, if the offences are not punishable with death, etc., then he will have to be released forthwith. Now, what they have done is, they have replaced this by 479(2), whereby they say that if at all there is another offence of which inquiry, trial or anything is pending, you will not get the benefit of this. Now consider a case, a person moves from a place, commits an offence, and then another offence is committed by him. He completes the half period of that, but in respect of the other offence which has taken place in the same transaction, he would be facing inquiry or trial. So he will not get the benefit under 479 because of this provision. Now, another provision which is introduced is section 250, which is replaces 227, wherein they say that within 60 days